morning is Emidio Piermarini versus City of Cuyahoga Falls. Each party will have 15 minutes in which to present the case. Appellant may retain up to 5 minutes for rebuttal. If the appellant wishes to retain some of that time, let me know when you come up to the podium and keeping track of the clock and keep apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read the briefs and we're ready to proceed with the vote.
Thank you, Your Honors. I'd like to divide 10 and 5 if I might.
Thank you.
If it pleases the court, my name is Mark Ludwig. I have the privilege of representing Emidio Piermarini by a referral from his general counsel, Ray Powell. I wanted to mention that to thank Ray again. This case presents 2 assignments of error regarding 2 misdemeanor convictions on no contest pleas. The assignments of error are straightforward. We have a complaint that the complaints did not charge offenses, and we have an assignment of error that even if they did, the recitation of facts wasn't sufficient to convict. The standard of review for both assignments of error is de novo, and we would urge the court to agree with us and discharge Mr. Piermarini. The transcript shows basically how routine no contest pleas in municipal court can become. The state basically recites some facts and the court finds the defendant guilty. The hope here is that although this certainly is not as important a case as the one you just heard, there's no murder involved here, but on a day-to-day basis in municipal court, it is good that this court once in a while reminds municipal courts how you handle a no contest plea, and especially this panel knows the difference between no contest in felonies and no contest in misdemeanors. The first assignment of error of no sufficient charge of the offense. The misdemeanor 1, misconduct in an emergency. And these don't stand alone, they stand together. 1, no subsection cited. There's 3 different ways you can commit it. 4, if you count the aggravating circumstance. 2, there was no misdemeanor of the 4th degree, so you can't have a misdemeanor of the 1st degree. But most importantly, on the misconduct charge, there was no allegation of physical harm. And that element of physical harm, the word physical, is what aggravates the offense.
But doesn't it say risk of physical harm?
No, it does not use the word physical.
No, doesn't it say risk of physical harm?
No, it doesn't say physical.
You 2 are talking 2 different things, the complaint as opposed to the statute.
Yeah.
He's talking about
Oh,
the
yeah.
statute.
Oh, the statute says, yes, you have to have a risk of physical harm.
Okay.
That is the element in this, thank you, Your Honor. That is the element in the statute that is entirely omitted. Now, again, it's only 1 word, okay? But tell an engineer that moving something 1 decimal point isn't important. We're not that strict, but strict construction does require that you include the elements of the offense, especially when that element aggravates the crime from M4 to M1, and that's what was omitted here. Now, in terms of the reckless operation, the second charge didn't state an offense because, again, not standing alone, but as all a package, there was no subsection cited. This is a due regard, willful and wanton disregard statute. It is not a reckless operation statute. And it was charged and argued as, quote, reckless operation. There's a big difference between the 2 that the case law makes and we've cited. Most importantly, the complaint that was filed says, and we've quoted in our brief, that this reckless operation offense was committed on a public highway to wit blank. Well, this wasn't a public highway. So the offense is, that's the first assignment of error. The second assignment of error is that the recitation wasn't sufficient. For an M4 misconduct, there must be evidence that the offense happened at the scene of an accident or emergency. And one thing this record is clear about, this wasn't the scene of the accident. The accident took place elsewhere, and people moved their cars into Mr. Piermarini's entranceway, and that's what he was upset about, including law enforcement officials who parallel parked an ambulance in front of the driveway when people were trying to get in. So there was no element of at the scene proven, and there was no element of emergency. I think this court has dealt with previously, we've cited in our brief, what an emergency is. And it's a little more than taking an accident report off the scene of the accident. Then the definition of emergency is not by statute, but by general rule. And the Legislative Service Commission comments are quoted also. So this was neither the scene of an accident or an emergency. Well, then maybe someone will say, well, we also allege that it was failure to obey a lawful order. Lawful order in the statute has to be in connection with, not defined term, in connection with the scene or the emergency of an accident. Now here, the in connection with, as was recited, was an order to stop his vehicle. But the complaint went on and said, to wit, he was driving recklessly. It said nothing about he failed to stop his vehicle when an officer said so. And again, this record comes to this court without certain things that are very easy to do. Move to admit some evidence at the no contest plea. We've got a dash cam video, Your Honor, I'd like you to review it, or not, if the defense waives. We've got an accident report. We'd like to include it in the record. We'd like you to review it, but if not, if the defense waives. We have the police narrative in connection with the charge. We'd like that to be part of the record. There's no motion routinely made in no contest cases where we move to conform what I just said, we move to conform the evidence to fit it, and the complaints to fit it. You got any objection? We'll come back after we retype it if you really want to go through that. Your Honors, I had the privilege for 25, close to 30, to work for Village Peninsula as their prosecutor. In a case where it's, let's say, Peninsula versus Jones, Your Honor, if it please the court, by plea negotiation, we've agreed to enter a no contest plea. That's the extent of our plea negotiations, including this factor. The defense will waive any presentation of evidence. Mr. Jones was charged with misconduct of emergency. The village incorporates the accident report and the officer's statements and moves to amend the complaint to conform. If you want things done routinely, do them right. Don't get in a hurry with what truly is, thank God, the number of misdemeanors that our courts have to deal with is much larger than the number of felony murders. That doesn't make one more important than the other. But this case presents that opportunity to remind the courts of some guidance for the no contest pleas. This court should grant the assignments of error and discharge Mr. Piermarini. Thank you.
Counsel, before you take your seat, I assume there was no motion to dismiss filed in regard to the complaint.
No, there wasn't, but again, under Rule 12, there doesn't have to be when you argue that the offense states no offense. It can then be made. And then, if Your Honor please, we entered a no contest plea and were found guilty before anybody said anything. Thank you.
Good morning. Thank you. May it please the court, my name is Brandy Roberts and I'm here on behalf of the city of Cuyahoga Falls. In the first assignment of error, where they argued that the charging instruments were insufficient, the standard is that in a criminal matter, the charging instruments must contain the essential elements of a criminal offense. It's not necessary that all of the specific facts relied on be stated in there that are required to sustain the conviction down the road. In State v. Oliver, the Supreme Court of Ohio held that the exact language of the statute is not required for an indictment, so long as the essential elements are stated. While this case specifically discusses an indictment that the Supreme Court decided in State v. Bergen, they noted that that applies to any charge, any criminal charging instrument. In Akron v. Holland Oil Company, this court noted that the primary purpose of the charging instrument in a criminal prosecution is to inform the accused of the nature of the offense with which he or she is charged. Here, the appellant was charged with first-degree misdemeanor of misconduct at an emergency in violation of Ohio Revised Code, Section 2917.13. In part, this section states that no person shall knowingly hamper the lawful operations of any law enforcement officer, firefighter, rescuer, medical person, emergency medical services person, or other authorized person engaged in the person's duties at the scene of a fire, accident, disaster, riot, or emergency of any kind. This section goes on to state that where a violation of that part of the section creates a risk of physical harm to persons or property, misconduct at an emergency is a misdemeanor of the first degree. The complaint, filed in this case in part, states that the appellant created a significant risk of physical harm to persons or property, and goes on to state that while driving recklessly in the parking lot of 48 East Bath Road, nearly struck an ambulance and a firefighter while they were on the scene of the accident and hindered police business. This is a violation of Section 2917.13 of the Revised Code, and it is a misdemeanor of the first degree because of that risk of physical harm to not only the firefighter, but the property being the ambulance that was there.
And that's not what was actually said in the complaint though, right? It's a significant risk of harm.
I have it quoted as it was a significant risk of harm in the complaint, but I know that that's not the language required by the statute.
That's
as a
what I'm
risk.
saying.
Yes.
And you're obviously arguing that the significant risk of harm is close enough to the risk of physical harm.
Yes, the risk of physical harm to the firefighter in particular is where we were concerned about in this case.
How do you address opposing counsel's contention that this was not the scene of the accident, that these people moved away from the scene and then into his driveway?
Well, Your Honor, I would say that while it may not have been the scene of the accident itself, the statute's broader than just an accident. It's also the scene of an emergency. There was a person on scene being treated in the back of the ambulance. I would argue that that qualifies as the scene of the emergency at that point in time. Also, while I agree with appellant that in the complaint no specific subsection was cited, it's not necessary. The complaint not only contains the specific language that's in the statute, but discusses some of the facts relied on, very specific facts for the charge. It did inform appellant of the nature of the offense with which he was charged, and that is what is required. In a traffic offense, under Traffic Rule 3, a defendant simply needs to be advised of the offense with which he or she is being charged, and in a manner that can be readily understood by a person making a reasonable attempt to understand it. Here, the appellant was issued a traffic citation. That serves as the complaint for the charge. The citation issued included the date, time, location of the offense, as well as the name of the offense, the reckless operation that's been brought up. Additionally, it cites the municipal ordinance, I believe it's 333.09, that charge is under. While the appellant does argue that the name of the offense is reckless operation and the standard pursuant to the ordinance is willful and wanton disregard of safety or purposes, I believe in his brief he argues that that means the appellant wasn't fairly warned of the charge. But being fairly warned isn't the standard. Again, the standard is they need to be advised of the offense in a manner that can be readily understood by a person making a reasonable attempt to understand it. I submit to you that the notation on the ticket that specifically cites the City of Cuyahoga Falls codified ordinance under which the appellant was charged was sufficient to advise the appellant of the offense for which he was charged. Therefore, I believe this assignment of error should be denied. In regard to the second assignment of error, the recitation of facts being insufficient, It is required that upon a plea of no contest, the state must offer an explanation of the circumstances to support the charge. This explanation is sufficient if it supports all the essential elements of the offense. And I know that it was argued that evidence could be offered, such as dash cam video or an accident report, or perhaps an affidavit, but that's not the standard. An explanation alone is sufficient if it supports all of those essential elements. In regard to the charge of misconduct at an emergency, the prosecutor for the city of Cuyahoga Falls described appellant hampering the performance of law enforcement on that scene and creating a risk of physical harm to persons or property. Specifically, the state said that while appellant was driving his car through the parking lot, he was going around the back of the ambulance. Lieutenant Maggie Hobson of the Falls Fire Department was walking around and nearly hit by the car. This shows a risk of physical harm to a specific person, Lieutenant Hobson. After this, the state recited what happened following that event. The officers went over to defendant's vehicle. Officer Hernandez got in the window and ordered defendant to turn off the vehicle. He said he would not, put it in reverse, which caused Officer Hernandez to be caught next to the mirror and was being pulled backwards by the vehicle. This explanation shows appellant hampering the duties of law enforcement, which is the first part of that misconduct at the emergency statute, by not obeying a lawful order to stop and turn off the vehicle. This shows another risk of physical harm as well. The officer was caught in the mirror of the car as the car was being put into reverse, and the officer was actually dragged in that process. The officer was not hurt, but certainly there was a risk of physical harm there. Therefore, this recitation of facts does state all the essential elements of the offense of misconduct at an emergency, as it's cited as a misdemeanor of the first degree. Finally, in regard to the charge of reckless operation, Cuyahoga Falls Ordinance 333.09B states, no person shall operate a vehicle on any public or private property other than streets or highways without due regard for the safety of persons or property. As I previously described, the prosecutor specifically described appellant driving through the parking lot, which is private property, and nearly hitting a firefighter. The prosecutor further described the officer being dragged by the car as he was trying to give a lawful order to the appellant. This recitation of facts is sufficient to sustain the reckless operation charge. Again, I would note that that subsection that I mentioned was not specifically cited. At least I don't think it was, but even if it wasn't, that's not necessary. The fact that that section at all was cited, that municipal ordinance 333.09, that gives the defendant or the appellant in that situation notice of what they're being charged with.
Of course, all that driving was on private property, not on a public road, correct?
Correct. And that is what's covered by that B section, that second section of 333.09, the reckless driving ordinance. I ask that this court deny both appellants' assignments of error and affirm the convictions in this matter. If there are no further questions, I will cede the remainder of my time.
The only question I have is just in regard to following up with Judge Teodosio. The ticket or the citation says defendant operated a passenger vehicle on a public highway, namely blank. So if he's actually charged with reckless operation on a public highway, right?
Yes, but I believe that the citation on the ticket, which is the charging instrument in that case, cites the proper section for which he was charged.
Thank you.
That being 333.09.
Yes, sir.
Please, the court 333.09 doesn't tell me whether you're complaining about public highway or private property. And then when you say 333.09 and describe the offense as, quote, reckless operation, that doesn't tell me that we're going to be proving willful and wanton disregard. So
Does it advise Mr. Piermarini in a manner reasonably understood?
no, Your Honor, I think the idea, the phrase of willful and wanton disregard is entirely different in the generic public mind of the word reckless operation. Now, which is worse as a matter of law, that becomes a question to be studied by the cases, but I don't think the words reckless operation forewarn you that you were operating with willful and wanton disregard. Now, one of the responses we heard was that the complaints don't have to allege all the facts. Well, we've never said that that's the standard. What we've said is complaints have to allege the essential elements of the charge. Now, the essential element of the first-degree misconduct of an emergency, to get it to first degree, is the word physical. And no matter how fast we continue to repeat the charges and insert the word physical, it's not there in the charges. And again, this is not a case where at the conclusion of the recitation, the prosecutor said, and we would move to conform the complaint to the evidence presented. It's a routine phrase that you can do, and boy, I hate to give it away like this, but it's a routine phrase that you can do that cures a missing element.
But
Or
not a necessary motion to be made.
a motion to amend to make the complaint conform to the facts I've recited.
Not necessary if the statement is of the prosecutor is adequate.
If the statement is adequate, but the statement is, we're not talking about whether the statement is adequate versus the complaint charge. This is the first assignment of error. The complaint doesn't state an offense for a first-degree misdemeanor. Now, routinely in no contest pleas, the court can find you at the misdemeanor level. The court can find you not guilty, but cannot find you guilty of the lesser included. The case law is clear on both those points. However, when you read the transcript, you see we stood there and said, maybe the evidence supports a misconduct to the fourth degree, inviting the trial court to find that the physical harm wasn't alleged and still giving us an out. Now, it's hard to believe, perhaps to some, that I wouldn't still be standing here complaining, but my head would hang much lower if I was. It was possible to get a fair conviction in this case, and the city passed on it. The fair conviction might have been a misdemeanor of the fourth degree for misconduct, no allegation of physical harm made or presented, and there we go. But we're past that now. This case has been found to state a sufficient complaint, both of them, and to state that there was sufficient evidence to prove both. There was no evidence in this record that there was a person in the ambulance. We heard that. There's no evidence in this record of that. There are two documents that are referenced as an appendix which were never attached. Now, perhaps I missed them. As I age, I miss things when I go through a record. But I didn't see either one of those documents in this court's record, the appendix documents in their answer brief. And yet they rely on those appendix documents to recite facts to this court. I got chutzpah, but I've never done that intentionally.
Well, I guess I'm still wondering with the actual complaint, when it says significant risk of harm to persons or property, and then it goes on to say that he nearly struck an ambulance and a firefighter. So a firefighter is a person, and that's physical harm.
No, you just did it. You just added the word physical.
Well, it's...
Your Honor, you added the word that a charging instrument doesn't have. And the
It doesn't, could I just...
Oh, I'm sorry.
No, you're fine, but I mean, could I just finish this thought before I forget it, as we forget it too? But what I was going to continue to ask you is, it does say significant risk of harm, but my point is, a firefighter, when you put those in that they almost struck a firefighter, that is physical harm. Now, I know it doesn't say that, I agree with you, but that's what the allegation is.
No, It's not what the allegation, the allegation is not what it doesn't say. And we can strain that as much as we like. The allegation is not what it doesn't say. The allegation is what it says. And it doesn't say, and I agree with Your Honor, it doesn't say physical harm.
No, it says harm to person.
Well, there can be other harm. There can be psychological harm. There can be, ooh, you scared me.
By almost striking me.
Yeah, I was palpitated by almost being struck, but that's not physical harm. Again, we would urge the court to discharge Mr. Piermarini.